the first to know Nsem-Pii TV.
Lawyer Paul Admochari. Lawyer Paul Admochari tenasi na exclusively you can't enchirichirimu about court proceeding na unyan baby a enye ebinom de biase ka so ofa yura I friend say with all due respect atemdidie Captain Smart atemdidie but Lawyer Paul Admochari in-depth knowledge about court case efa the ambulance case Ato Forson case nkoye 2-1 na eno na Lawyer Paul Admochari numeri or the exclusive detail was set the record straight actually the course and the eba bebe nyina na already we sitie na so nya privilege na oyese one yewura odame edin gomo but na odame be issue statement na wachirechiri nyina ma bibia da hope fe say Lawyer Paul Admochari was setting the record straight. Therefore, we who the entire year 2-1 na case no a fade the NDC for a case court no omo good. Na didn't see obe chim say didn't see say modi a common the court is good. Na say a court ya o dia. One shall say now can say unanimous FC on the resident yeah they are NDC for the biases are too much because social media correct and Lawyer Paul Admochari actually semuli de da ato de da therefore mranjam yanko the Lawyer Paul Admochari means about it you can be.
This appeal was made some time ago when they filed a no-case petition before the court and the High Court rejected this, so they went to appeal. So it came as quite a pleasant surprise. But it shows that we still have justice in this country. We can work to make the judiciary that we want. Oh, please, I hope this is not my people who didn't write it well. Oh, please, producer, did you copy President Mohammed's thing properly? Hey, producer is telling me that he copied it properly. Oh, he has bought the original. Oh, this is beautiful. Anyway, you get me back. I don't like President Mohammed is president. You leave him. Bring back the judges. Bring back the judges. Let's finish that. I give it. So all three judges were appointed by Nana Addo Dankwa Akufo-Addo. And it is the NDC who in 2019 and 2022 came and said that the Akufo-Addo has appointed, he's packing the court. He's packing the court. These all three judges were appointed by Akufo-Addo. They have delivered a 2-1 verdict in favor of Ato Forson. That's what they've done. And then now, what are we saying? Anyway, so let's understand the case. Give me the hierarchy of the court. So viewers, this is my submission in terms of how I can explain the case. So a trial causing financial loss to the state usually will begin at the High Court. So assuming that Stan Dogbe is charged for defrauding by false pretenses, contrary to, you see, that's how they charge you. They will, because you see, they can't charge you for something that is not already written down, because the crime and the offense that you have committed must have been thought about by the lawmakers. So when the lawmakers sit down, it is predictable. So when you do something, there's something that you have done, the narrative of what you have done, they bring it onto the table, say what you have done, and see which one fits. So Stan Dogbe told Paul Admochari that he will buy him a yacht in Las Vegas. Paul Admochari parted with $50,000 to Stan Dogbe to buy the yacht in Las Vegas. Stan Dogbe was aware that at the time that Paul Admochari gave him the money, or at the time that he, Stan Dogbe, made representation before Paul Admochari that he is able to acquire a yacht for Paul Admochari, Stan Dogbe knew or ought to have known that he is in no capacity to buy the yacht. But Stan Dogbe nonetheless presented himself as one who is able to buy a yacht. So Stanislav Jose Dogbe took $50,000 from Paul Admochari, and Paul Admochari's expectation was that he will be given a yacht in Las Vegas, so that when Asante Kotoko beat Hasselfolk, he will take the Kotoko boys to Las Vegas and put them on the yacht, and they will sing Kuma Pima Pimbeba, Kuma Pima Pimbeba, etc. Okay. Doesn't pick. When his PA picks, he's insulting me. So I don't know what to do. The police will say, what is the address of Stan Dogbe? I said, I have his phone number. The government prosecutor goes to court. So they go to, because depending on the offense, you see, The law has decided that if it is stealing, you go to circuit court. If it's this, you go to that. Most of the high-profile offenses, you start at high court. Actually, there's no criminal prosecution that begins beyond the high court. There's no criminal prosecution, except, is it treason? So he comes to the high court, like Ato Forson and co. The prosecution will start to make their case, okay? So they'll say that you, Standobe, on so and so date, or let me use the actual actors. You, Ato Forson, on so and so date, you did this and that and that and that and that. Prosecution, whatever they say, they will prove it. How do they prove it? So they invite their witnesses. Witness 1, Godfrey Yebo Adame. He comes. They call him PW1. PW means prosecution witness 1. Okay. So prosecution witness 1, prosecution would actually have to tell the court that I'm calling 7 witnesses. Prosecution cannot add an 8th except with permission of the court. The lawyers would like to confuse you. They say except with leave. Leave means permission. Don't worry about that. I'm here to help you, please. Don't worry about the lawyer's language. Everything they say, I understand. I will help you. Every Latin they say, I understand. I will explain. Don't worry. So when the lawyers say, you need leave of the court, then they can't. Did you get leave? They mean permission. If they know that if they say permission, you understand, but they want to be boss. So, yeah, permission. Forget about leave. So they need the permission of the courts to add an 8th person because they have already told you the defense that they are going to call 7 people. So they can't call 8. The 7 people, they give their names to the court and their names to the defense. We'll be calling Anziba, Michelangelo, Apreku, and they will also tell the court that when Apreku comes, he will be asked questions about this and that and that. So the defense lawyers are already aware. So in case they say when Apreku comes, they will ask him about something called nomenclature. Defense lawyers will look at it and say, boss, what's nomenclature? Let's check the dictionary. They Google it. Oh, we understand. Okay, that's what there are no surprises in court. If you create a surprise, the judge can cancel it. No matter how valid it is, it ought not to be a surprise. I'm explaining the high court criminal procedure. Okay. So all those things are not allowed. Surprises are not allowed. You can't surprise anybody in court. So as soon as you say something that they are not aware of, they didn't know you were coming to say it, they are not prepared for it, the lawyer will say, my lord, he's surprising the court. This was not in the brief. The judge will say, but prosecution, was it in the brief? You can't use it. You didn't put it in the brief because you have to put everything in the brief. If you find something new in the brief, you file an application to the court that day. When you file the application that I want to add iPhone 17 evidence, the defense will be asked that do they agree they will oppose the application. They may oppose the application. In fact, if they oppose the application and the judge doesn't listen, they can go to the Court of Appeal. Those are the things we call interlocutory applications. That is applications that occur in between the beginning of the trial and the end of the trial. The trial can start and go on without any problem, without any interjection. But where there's an interjection, where the judge has to make a ruling. So all the decisions that the judge makes during the court is called ruling. At the end of the day, it's called the judgment. So the judge is required to make decisions on small things as they are going along. So an example, the guy comes to court one day and says that I am doing this. Prosecution says, no, my lord, you can't do that. He said, my lord, we oppose the application. Why do you oppose it? My lord, contrary to Article 16 of the Republican Constitution, he's not able to do that in a criminal trial. The judge says, give me 3 days to look at this. That's how the cases delay. So the judge takes 3 days, comes back and said, my ruling by court, I rule that the paper that he was trying to adopt and submit, it is taken. When it is taken, the one who has lost it can say that, my lord, I don't agree with you. I'm going upstairs. So he files an application on only that one to the Court of Appeal. When he files the application, because these days there's been complaint from the Bar Association, civil society, interlocutory applications are guided in a certain way. So when he files, the judge can say that you can file your appeal, but I'm continuing with the case. If the lawyer feels that continuing with the case will hurt him, he will file what they call a stay of proceedings. In filing the stay of proceedings at the High Court, he will tell the judge that it is meritorious and it is fair that you wait for me to go to the Court of Appeal to hear this decision before I come back. The judge can say no. When the judge disagrees with the stay of proceedings, he is most likely to go on with the case. That disagreement of the judge of the stay of proceedings can also be appealed against. So you go to the Court of Appeal and say, I filed a stay of proceedings. The High Court judge says he won't listen. 3 Court of Appeal judges will listen and they can tell the High Court that the stay of proceedings has been granted. Or the stay of proceedings was not granted. If the stay of proceedings is not granted at the Court of Appeal, on that small matter, he can go to the Supreme Court. And the Supreme Court, 5 judges will sit and say, we have granted it, we haven't granted it. If they don't grant it, he will go to Supreme Court review. Now, who is the master of that? Chachu Chikata. Chachu Chikata. He's the master of interlocutory applications. He is the Maradona, the Pele of interlocutory. Oh, Chachu. Small thing. Oh, my Lord, I'm going to the court of appeal. I will not accept this. I go to the court of appeal. He goes to the court of appeal because I agree with the high court. Oh, no, my laws, I'll test it at the Supreme Court. He goes to the Supreme Court and the Supreme Court review. That's my Lord, Mr. Chikata. So I'm just trying to explain. I'm coming to tell you what happened today. So this matter is at the High Court. Prosecution, when the prosecution finished their case, everything they say they have to evidence it, bring witnesses and all that. When they have closed their case, they will tell the judge that, my Lord, this is the end of our submission. We are finished. This is the amount of evidence we have against the accused person. This is all the evidence we have presented against the accused person. It is now time for the accused person to open his defense based on everything we have said. Accused person stands up and says, my Lord, everything they said, they didn't say anything. Now, what is that based on? It is called a submission of no case. It is the accused person saying that from all what they have said, they have not been able to show that there's a case for us to answer. How do they do that? They do that based on what we call the ingredients of the offense. So every offense has ingredients, like food has ingredients. So stealing has ingredients. First of all, you must show that an item has been stolen. 2, or money has been stolen, or something has been stolen. 2, you must show that the person who stole the thing, it didn't belong to him. You must show that this and that and that and that. So for instance, you say I've stolen a mobile phone. And then I come to court and I say the mobile phone you say I've stolen belongs to me. So when you are finished doing your case, I tell the judge that I'm submitting for no case. The mobile phone they say I've stolen, it is for me. How can I steal my own thing? The judge will say, yes, you are right. Submission of no case granted. Prosecution, you have not been able to make any case against Paul Adomoche. Adam, good night and God bless you. And I go, then they pour powder on me, then I do, allow me to kiss your hand. So that's submission of no case, by the way. So when the prosecution in this Ato Forson closed their case, Ato Forson and his lawyers decided that they will file a submission of no case. In criminal trials these days, it's almost to be expected that the defense people will always file a submission of no case. Who do you file a submission of no case to? You file a submission of no case to the High Court judge, the same judge. So case Ato Forson, after Godfrey Dame and the prosecution has said everything they will say, decided to file a submission of no case to the High Court judge. The High Court judge heard the submission of no case and disagreed with Ato Forson's lawyers and said, no, from what the prosecution have done, they have established the ingredients of the offense. You will need to prove your case. You will need to defend yourself. If you don't defend yourself at this stage, I'll jail you. But if you can defend yourself, I'll listen to your defense. I'll compare it to what they are saying and I'll make a decision at the end in my judgment as opposed to ruling. Okay. So the High Court then told Ato Forson that you have to answer. That's the question I was asking these people, my friends this morning, that did they file a stay of proceedings? And I think I got the answer that they didn't. You can decide not to. So when their submission of no case failed at the High Court, they filed a submission of no case at the Court of Appeal, whilst the High Court continued with the case. So they opened their defense anyway at the High Court, as they were required to do by the judge, because their submission of no case failed. So when they opened their defense, then their defense, that's when Jakpa came in with all that, Setekpe came in. That is the defense lawyers defending themselves in the High Court process. Meanwhile, the appeal against their failed submission of no case was pending at the Court of Appeal. So they filed the process. When they filed the appeal, the Attorney General is supposed to respond. When you go to appeal, as they tell us in school, when you go to appeal, what is on trial is the decision of the judge that you are appealing against. So the lawyers are always keeping an eye on the Court of Appeal judges to be sure, as they say, that they are not trying the case anew. That's the language the lawyers use. That they are not trying the case anew, that they are looking at what the High Court judge did. Because what is on trial at the Court of Appeal in any process that is arising out of the High Court is the judgment of the High Court. That's what is on trial. Okay? So the Court of Appeal looked at the judgment of the High Court. They are looking at why the High Court decided that case Ato Forson has a case to answer and that his submission of no case should be denied. Why did the High Court make that decision? So the Court of Appeal is looking at why the High Court made that decision. This morning, the Court of Appeal said they have looked at the High Court judge's decision and they do not agree with her. They think that she didn't look at this, look at that, look at that. On the basis of that, they, the higher court, the Court of Appeal, are making a decision that Ato Forson's submission of no case should have succeeded at the High Court. It didn't succeed. They are a higher court. In the circumstances, they deem Ato Forson's submission of no case as successful. This morning, 10:20, the Court of Appeal ruled as such. Court of Appeal is 3 judges, so that we have more heads looking at what the single High Court judge did. And then when you go on to Supreme Court, you have even more heads looking at this. That is the beauty of the judicial system and the democracy. So the Court of Appeal decided today, this morning at 10 a.m., that the High Court judge was wrong. So the High Court judge is the one that the Court of Appeal is criticizing, not the Attorney General, by the way, technically. That the High Court judge, who happens to be a Court of Appeal judge, sitting as an additional High Court judge. Next time I'll explain that. Today we don't have time. That the High Court judge made a mistake when she decided that Ato Forson has a case to answer. Because in their view at the Court of Appeal, in the view of the majority of the Court of Appeal, the 2 of them, Ato Forson has no case to answer. He should go away. His submission of no case is successful because the prosecution has not been able to establish a case against them that they need to answer. If the prosecution is not able to establish any case, then they don't need to answer. So that is what the High Court, Court of Appeal decided this morning. That the submission of no case, Ato Forson says that after everything the Attorney General said, he has said nothing. I don't have any case to answer. After Baby Ben or Kaini, there's nothing in it. And the High Court judge said, who told you there's nothing in it? Come and answer. So they started answering. Court of Appeal said, 2 of the Court of Appeal judges said, I agree with the High Court. So that's what happened. Now, a submission of no case, if he succeeds at the High Court, that's the end of the case. That's the end. So you can ask Kwesi Ahoy. During the trial of Quality Grain, his submission of no case was successful and he walked away. That's the end. He's gone. It's finished. It's finished. You brought a case against me. You took me to court. You told the court about the case. The judge said that after all what you said, I don't have a case. I've not done anything wrong. So I'm gone. So when the Court of Appeal made that decision this morning, it meant that Ato Forson is free to go. But that's not the end of the pyramid I put here. The Attorney General has indicated that he is dissatisfied with the decision of the Court of Appeal. Therefore, please put the pyramid back. I'll come to the Attorney General. Therefore, he is going to rise above that and go to the Supreme Court and let 5 judges look at what the Court of Appeal 3 judges decided. In any case, one of the 3 judges decided that Ato Forson has a case to answer. 2 of the judges said that Ato Forson has no case to answer. 2 is greater than 1. And therefore, in majority, Ato Forson wins. But now, the Attorney General says, no, I don't agree with that. As an appeal is as of rights, especially at the Court of Appeal, where it's 2-1. Even if it's 3-0, you still have the right to do so. But where it's 2-1, the lawyers are going to begin to watch with very eager eyes. Because the Supreme Court now has a basis to start. That there's 1 that says no, 2 say yes. Let's look at the 1 that says no. Let's look at the 2 that says yes. Let's look at Godfrey Dame's record at this time. In the Opuni trial, Opuni was able to win at the Supreme Court with a 3-2 majority. Godfrey Adame decided that no, that the 3 were wrong. He asked for a review of the decision and he won the review of the decision and Opuni lost. That is the apex, the end of the trial. After Supreme Court review, it is called in Latin res judicata. Please Google it. Res judicata, what does it mean? You see it. When the matter is finished, it is called res judicata. There's nowhere else to go. Because, as the lawyers say, there has to be an end to litigation. You understand? Okay. So, that is what is happening now. Court of Appeal have decided by a 2-1 majority that Ato Forson has no case to answer. He's gone. That's why they reduced the powder. Because they haven't finished. If it is the Supreme Court review, they will carry Ato Forson's body and dump it into powder. Because why? We are at res judicata. Our son is finished. But now it's not finished. It's not finished. Court of Appeal has ruled. Attorney General says I'm going up. Viewers, I hope you understand what I've said. If you don't understand it, send text messages. Thursday, I'll come back to this topic and explain it better. Let's see what the Attorney General said as we conclude on this matter before we get to Dodo. Oh, it's 11:30 now. So the Attorney General says in his press release, I start from the second paragraph. It says, the Office of the Attorney General considers the decision of the Court of Appeal to be perverse in the quest for public accountability and the rule of law. The decision clearly is heavily against the weight of the cogent evidence led by the prosecution in the substantiation of all the charges against the accused persons at the trial. The relevant facts of the matter, as borne out by the undisputed evidence led so far, show that vehicles purported to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. B, the then Minister for Health, Mrs. Sheriaite, had cautioned in writing against